The main source of criminal law in Canada is the Criminal Code. It describes which acts are offenses and also explains their punishments. The Law Reform Commission has outlined 4 conditions that must exist for an act to be considered a crime. The act must be considered immoral by most Canadians. The act must cause harm to individuals and society. Harm caused by the act must be serious in nature. The person must be punished by the criminal justice system. Governments regularly change laws to reflect the views of society. As societies change, so do many laws. When determining whether or not an act is immoral, the following terms are important to understand. Legal. This is any action that does not cause harm to others and is not against the law. Illegal. This is an action that is considered immoral, not legal, but is also not criminal. Criminal. This is an action that is considered immoral and potentially harmful to others. This action is included in the Criminal Code. The Law Reform Commission has also defined 7 principles of procedural justice, or fairness in the justice system. First, fairness. It shows no bias towards the accused. 2, efficiency. Process is timely with no lengthy delays. Clarity. The accused understands the process. 4, restraint. Officials are disciplined and professional. Accountability. Officials are responsible for their actions. Participation. Process must be open for scrutiny. Protection. The accused is not abused by the officials. In Canada, there are 3 types of criminal offenses, which are classified and prosecuted according to their severity. There is a summary conviction, a less serious criminal offense, also known as a misdemeanor, for example, shoplifting. Indictable. A more serious criminal offense with a severe punishment, for example, murder, which would give you life imprisonment. A hybrid. A criminal offense in which the Crown decides how to treat the charge as either a summary or indictable offense. There are maximum penalties set for each type of offense. The summary offense is a $2,000 fine and or 6 months in prison. The maximum for an indictable offense is life in prison. For a hybrid offense, it could be 2 to 10 years in prison. A time limit to lay charges is known as a statute of limitations. In a summary offense, charges must be laid within 6 months of the alleged incident. In an indictable offense, there is no time limit or statute of limitations. Charges can be laid several years after the alleged incident. In a hybrid case, it depends on whether the case is being tried as a summary offense or an indictable offense. There are 2 basic elements required for a person to be guilty of a crime. Actus reus, a wrongful deed or guilty act. Mens reus, a guilty mind or the mental element. This Latin phrase stands for, the act will not make a person guilty unless the mind is also guilty. Once a prosecutor establishes that an accused person physically committed the crime, actus reus, he focuses on proving what the accused's intention or state of mind was at the time of the offense, mens reus. Common types of mens rea are recklessness and willful blindness, knowledge, motive, attempt, conspiracy. Recklessness is the careless disregard for the possible results of an action. For example, a person knows they have a sexually transmitted disease and they have unprotected sex with someone. They may not intend to hurt that person, but their actions are reckless. Willful blindness occurs when someone purposely chooses to ignore certain facts or information, turning a blind eye to something. For example, delivering an unknown package for a known drug dealer without asking what's in it. The knowledge of certain facts or simply knowing something can lead to mens rea. For example, using a credit card that you know is expired or invalid. An accused reason for committing a certain act is his or her motive. This is not the same as knowledge and is considered circumstantial evidence, but understanding why a person would commit a crime is helpful to police and can be used effectively by a prosecutor. A person who intends or attempts to commit a crime but fails to complete it can still be found guilty of a mens rea offense. For example, if John tries to kill Jennifer but fails to do so, he is still responsible for his actions and is charged with attempted murder. An agreement between two or more people to commit a crime is a conspiracy. For example, Linda and Nathan plan to break into a house and steal the electronics. It is possible to be a part of or to contribute to a crime without directly participating in it. Being a party to an offense is also a crime. It could be aiding and abetting, accessory after the fact, or being part of organized crime. A person may be charged with aiding if he or she assists or helps someone to commit a crime. For example, Troy robs a store while Raj keeps a lookout for the police. Raj can be charged with aiding Troy in his crime. The act of encouraging a person to commit a crime is known as abetting. For example, Tara complains about how much she hates her boyfriend and Sheila encourages her to hurt him. Sheila can be charged with abetting if Tara actually hurts her boyfriend. If a person knows a crime is being committed but helps the person who committed the crime escape or hide from the police, he or she may be charged as an accessory. For example, James kills someone and runs to his best friend Nick's house for help. Nick gives James some food, money, and the use of his car. Nick is an accessory after the fact for helping James evade the authorities. Outside of civil law, there are mainly 5 types of courts in Canada: the Provincial Court, Criminal Division; the Provincial Superior Court, Appeals and Trials; Provincial Court of Appeal; Federal Court; and the Supreme Court of Canada. The Provincial Court, Criminal Division, arraigns the accused, that is, reads the charges and enters the plea. It holds preliminary hearings for very serious indictable offenses. It hears and tries summary conviction offenses and less serious indictable offenses, for example, theft under $5,000. The judges for this court are appointed by the provincial government. The Provincial Superior Court tries the most serious crimes, for example, murder or robbery. It hears criminal appeals and summary offenses. It sets provincial precedents, that is, new decisions that must be followed by other judges in that province. The Provincial Superior Court can be a judge alone or a judge and jury. The judges are appointed by the federal government for this court. The Provincial Court of Appeal is the final court of appeal in the province. It sets provincial precedent for other judges to follow. It has 3 to 5 judges to hear the appeals. The judges for this court are appointed by the federal government. The federal court is divided into 2 parts, the Federal Court and the Federal Court of Appeal. It hears legal disputes that involve the federal government. For example, jurisdiction, immigration, and copyright issues. Decisions of this court may be appealed to the Supreme Court. The Supreme Court of Canada is the highest court of appeal in the country. It hears appeals, but only under certain conditions. The issues must be of national importance, and a law is required to be interpreted. It has unlimited jurisdiction and usually sets national precedents when issuing a decision. There are 9 judges on the Supreme Court. They are appointed by the federal government and can serve until they reach the age of 75.